Today, Vusimuzi Matlala is running out of road. The man his own advocate admits has been painted as the mastermind was set to testify at the Madlanga Commission. But on Monday, his plea deal with IDAC collapsed. And now his legal team is begging for a postponement days before his criminal trial begins. The commissioners were not having it. Pressed for a straight yes or no, his advocate was cornered again and again and again, until the answer finally came. The statement will be filed. And the evidence leader's verdict on his broken promises, that undertaking is not worth the paper it's written on. But that's not even the wildest moment of the day. A second witness, whose companies were allegedly paid hundreds of millions of rands by the Northwest government, sent a doctor's note from his hospital bed on the very day whistleblowers say he was spotted shopping at Woolworths and having a long lunch. The commission has now subpoenaed the CCTV, the hospitals, and his doctor. Remember, these are allegations. No one here has been convicted. If you want the truth, South Africa isn't shown on the news. Like this video, subscribe, and hit the bell. Now, let's go inside.
For what purpose? You are doing that for what purpose?
For purpose of invoking my right to silence on that. I can say
no,
I've been
then
told...
you don't get me altogether. Then you don't get me altogether. We have already, please listen to me. We have already made common cause that there are issues in respect of which Mr. Matlala is able to deal with before this commission. Now, you are talking about issues that, post the plea deal, may also fall under the Section 35 dispensation that you are claiming. I have said, let's put aside all of that. So what you are telling me falls, according to you, under that basket. I have said, let's put that aside. And let's address our minds to those issues about which there is no question regarding them being heard by this commission. That is what my focus is on. And it's on that basis that I say to you, I do not understand your point about the plea deal and its relevance to my question. I hope you get me now.
Let me again try and explain to you, Commissioner or Chairperson. I can only say to you, we've made common cause on the issue itself. But I can only tell you, as an officer of the court, which of those...
No, I will not give you time when you seem not to understand me. I am saying, I'm not interested in the nitty-gritty of what falls under the Section 35 bucket. I'm not interested in that nitty-gritty. I'm looking at the broader question of, on those issues on which there is no question whatsoever, which can be dealt with by this commission, and you've agreed that there are. On those questions, why can't those questions be heard before the criminal process has been finalized? Whether, even accepting, as you argue, that there are some issues coming out of the plea deal which fall under the Section 35 basket, even accepting that, you have said there are some which do not fall under that basket, and my focus is only on those aspects that do not fall under that basket. So clearly, what you've just said about the plea deal is irrelevant to my question.
With the greatest of respect, it's not irrelevant, Chairperson, because I cannot at this point in all, as an officer of the court, distinguish between what we can answer and what we can't answer. We can only say to you, the only things...
You will never understand me. Please go on to your next point.
I do say...
No, don't go to the other things. Right. I'm more interested in the question of principle. I want to establish the principle. It's important to us. If by the time we finish here, you rise and your position is until he has received the IDAC material, or you have received the IDAC material, whenever that will be, maybe tomorrow, maybe day after tomorrow, maybe next year, maybe not ever. I want to establish the principle to make sure I understand the principal position. Is the principal position that until you have received and considered, as his counsel or his legal team, until you've received and considered the IDAC material, Mr. Matlala will not file a statement and he will not testify. Is that the position you are conveying to us?
Until such time I am told by any person in the legal profession that I'm wrong in going to a point where I say part of what I'm doing here is to protect my client's rights. I stand by that.
Yeah,
I say it is
I must insist, Ms. van der Heever, I've asked a direct question. Let's stop this going around. I'm not asking you about being advised by somebody, being told you're right or wrong. And I haven't yet expressed a view that you're wrong, by the way. I'm not saying your position is wrong, right? I'm still at the point where I want to understand the position. And it is a yes or no kind of question. You have motivated, you have argued, and you don't need to do that any further. I'm now at a point where I want to understand, is the position that until you have the IDAC material, Mr. Matlala will not file a statement and Mr. Matlala will not testify? The answer is a yes or no.
My instructions are that we will file a statement as soon as possible.
What is your answer to my question?
I've told you, Commissioner.
So you will file a statement even if you do not have the IDAC material?
That is my instructions at this point.
Okay, that you will file the statement.
I got instructions from my attorney to deal with it.
Thank you. Thank you.
I would like to start with where my learned friend ended, which is an offer to file the statement in 2 weeks. That effectively takes care of the first part of the ruling, or was it the second part, but one part of the ruling of the 7th to file in 2 weeks. We have spent over an hour engaging, or my learned friend engaging you on matters that don't get to that conclusion. That's where she ought to have started and would have saved significant amount of time. I say this because on reading the affidavit in support of the application for postponement, one must bear in mind that we appeared before you on the 7th of July. Everything that is in that affidavit predates our appearance. And it is at that appearance, notwithstanding the facts as asserted in that affidavit, an undertaking was made. So if those facts were not relevant prior to the 7th, and the very facts, notwithstanding the very facts, they were able to make specific undertakings, which included filing by the 8th of July and appearing on the 15th, I truly do not understand how then they become relevant come the 15th. They revive, they suddenly become relevant. The challenge with this application is nothing in the affidavit speaks to the period between the 7th and the 15th. Nothing happened that even threatened the undertaking made to you on the 7th, Chair. So the question is, why must I entertain this entire argument if not to waste the Commission's time? Mr. Matlala's legal representatives were informed by certain facts to conclude that they're in a position to make certain undertakings on his behalf. They don't come here and say, those facts have changed. They don't come here and say, since the undertaking was made, new facts have come to light that make it impossible for us to comply. So technically, that undertaking made is not worth the paper it's written on. And this is a complete waste of the Commission's time.
Time as we've reached the end. If I may just use an opportunity to just deal with one issue. I got a random message from somebody on my phone telling me that I'm not allowed to shout at you, Chairperson, or the other commissioners. I just want to make it plain that I don't shout, I just speak very loudly. Most people know that. So I am sure you didn't perceive it as shouting, neither yourself nor the other commissioners I spoke to. Just for people that don't know me, I speak very loudly. It's not shouting. Thank you very much, Chairperson.
If it gives you any comfort, Ms. van der Heever, let me tell you that A judge, when I was appearing in the Mthatha High Court, once shouted at me saying I should not shout at him. So,
Then we're in the same boat, Chairperson. I'm very happy to hear that. Thank you.
thank you. Oh, one other thing, at least based on the agreement that has just been conveyed to me, I assume that you will not be insisting on reasons for the fact that we are saying the hearing will be continuing.
I do not need
Thank
any
you.
reasons. May it please you. Thank you.
Thank you, thank you. I thought I should just take care of that because there was the muted reference to the possibility of a High Court application. So one might say no reasons were ever given for an application that we made.
Like they say, I don't roll that way, Chairperson.
Thank you. I make the following ruling. Mr. Matlala must file his statement not later than 29 July 2026. And that's one. Two, the hearing of his testimony is postponed to 1 September 2026 to continue until the hearing has been finalized. Good morning, Mr. Shaskalson. Good morning, Mr. Premhead.
Morning, Chair.
Morning, Chair. Morning, Commissioners. Chair and Commissioners, you'll recall that 3 weeks ago, Mr. Karim was postponed to today's date. He's not here today, and we received a doctor's note yesterday that refers to his admission to hospital on the 17th of June, which is more than a month ago. When we received that doctor's note yesterday, it seemed to explain Mr. Karim's apparent inability to appear today, but it didn't explain his inability to answer, at least in part, the Regulation 10.6 notices that had been served on him and that I addressed in the Commission 3 weeks ago. You'll recall, Commissioners, that we're still waiting for Mr. Karim to tell us, for example, who the auditors of his companies are. There's nothing in his doctor's note that suggests that his health conditions are of such an order that he's been unable to do that for 2 months. Similarly, we're still waiting for Mr. Karim to furnish audited or even unaudited financial statements for 3 of his companies, Ziggy, Tasmika, and Tamiz. There's nothing in the doctor's note that suggests he'd have been unable to issue a simple instruction to the officers of his companies to do this. And I want to emphasize here, we're talking about a group of companies, including Ziggy, Tasmika, and Tamiz, that have been paid hundreds of millions of rands from the Northwest Provincial Government and Northwest municipalities in the region of which he's the ANC Treasurer. Companies in this group continue to perform services for those organs of state and continue to be paid millions of rands by those organs of state. We're talking about multi-million rand businesses, not, family-run sort of small businesses that have to shut down if their owner is unwell. So if Mr. Karim took the trouble to ask someone, he ought to have been able to arrange that we receive the financials we've been asking for months now. That's where things stood yesterday. Mr. Karim seemed to have an excuse for not appearing, but he did not seem to have any excuse for failing to answer any of the questions in the Regulation 10.6 notice we sent him 2 months ago, and for not providing any of the documents we sought in that notice, almost all of which he had undertaken to provide when he testified when he was healthy back in, I think it was April. That was yesterday. And then after we received the doctor's note under cover of a letter from his attorneys yesterday, late in the afternoon yesterday, we received 2 different whistleblower reports, both confirming that Mr. Karim and an entourage had been seen yesterday going out for lunch at a shopping centre in the Western Cape. The two reports corroborated the same details. They seem to be independent of one another, and they've now been confirmed by eyewitnesses at that shopping centre, who we have independently contacted. So we now have it from multiple different sources that someone who seemed very much to be Mr. Karim arrived at the shopping centre with an entourage, went into Woolworths before going off to have a late lunch at a restaurant in the shopping centre. We've subpoenaed CCTV footage from the shopping centre, and we expect to have it received, and we expect to have it thoroughly analysed by midday tomorrow. For now, we have a concern that Mr. Karim may be taking liberties with this commission. And that concern is amplified by other whistleblower reports that we've received indicating that Mr. Karim has been seen at social gatherings in the Northwest over his period of ostensible incapacity. So we are going to issue a subpoena later today to the hospitals at which he's been receiving treatment to establish when he was admitted and when he was discharged, since he testified at the commission. We're also going to be issuing a subpoena to his doctor, who's based in Cape Town, to establish the dates on which he has seen Mr. Karim. And we don't expect that it will take us more than a day to obtain this information. And what we would like is for the matter of Mr. Karim's appearance, or non-appearance, to be stood down until Friday morning, or maybe Friday lunchtime, when it can be considered on the basis of a formal postponement application, which we would ask this commission to order him to bring by 10 o'clock tomorrow. The evidence leaders will reply to that postponement application by 6 p.m. tomorrow, and it could be heard by Friday morning at 9:30. If Mr. Karim's legal team needs more time, if we can have that postponement application by 5 p.m. tomorrow, we would undertake to respond to it by 10 on Friday, and it could be heard on Friday afternoon, not Friday morning. But what we do expect the postponement application to address is at least the following issues. The dates on which Mr. Karim has been admitted to hospital over the last 4 months, the dates on which he's attended medical consultations over the last 4 months, his travel movements over that period, whether he's attended social engagements over that period, and whether he's played any role in the management of his businesses over that period, and if not, who's been responsible for these businesses which continue to turn over in his absence.
Ms. Jaskelson, can you please add one more thing? I'm interested to know how he traveled from the Northwest to the Western Cape. Did he book flights? Did he fly there? Because if he can give instructions to people to book flights to him, surely he can give instructions to people to give you the names of accountants. Thank you.
Mr. Jaskelson, any reply?
A brief reply, Chair. First, in relation to the businesses, why I mention the businesses is not to say that these are unlawful earnings or that these earnings are, proceeds of crime or anything like that. It's to say there is a very substantial business group that is carrying on in the apparent absence of Mr. Karim. And if the group can carry on in the apparent absence of Mr. Karim, then it's not clear to us why we can't get, through a simple request from Mr. Karim, details like financial statements of 3 of those companies in the group, the identity of the auditor of 3 of those companies who we still haven't been able to ascertain from repeated requests to Mr. Karim. So if he can keep his businesses ticking over remotely from his sickbed, he can also issue an instruction that the information that exists external to him can be made available to us. And he hasn't done that for months now. The second issue in relation to the medical report is it's curious to hear my learned friends saying we haven't impugned the validity of the medical report, because last time we were here, you'll recall that there was suggestion on the table that Mr. Karim should make himself available for independent medical examination, and we were told, oh no, you don't have the powers to do that. You're not a high court with powers under the rules, you can't do that. He won't make himself available without you, and you don't have the power to do that. So now we're told you can't examine him, you can't get an independent medical report, but when you have extrinsic facts which give reason to doubt that he is unable either to appear or to furnish information that you've asked, you cannot raise them because you're not impugning the medical report. Well, they can't have it both ways. If Mr. Karim wants to make himself available for our own independent psychiatric or other medical examination, we will do that. We will do that, and we will arrange that an appropriate specialist dealing with whatever medical conditions he has raised, which range across a very wide spectrum, are investigated and a report is furnished.
In how you've described it, just how you've captured it now,
Sure.
that seems a typical HR matter that the Public Service Commission would deal with. If you had taken this affidavit to the PSC, and I'm saying just from how you've captured it, that it seems something that falls squarely within the powers of the Public Service Commission. And you took exception yesterday quite strongly to General Mkwanazi saying you lack the experience to investigate matters. Yeah, rightly so, because you've taken us through your qualifications. But as an experienced investigator, even acting on your superior's decision, Ms. Johnson, maybe Perumal, and whoever the committee is, them having made a decision that this is a matter to be investigated, I would expect that you, as an experienced investigator that you are, you would have looked at this affidavit and said, but this is an HR matter where government has an institution that deals with these kind of complaints. There is nothing, at least that when I look at it now, I don't, maybe let me rephrase what I want to say. Looking at this paragraph 2, I don't see how you would have thought this is a criminal offense when you look at the facts that are alleged in paragraph 2, and yet I can see how you would say, but this is an HR matter, what are we doing with it? Because remember, at this point, you don't know anything else. At this point, when you get this affidavit, you don't know what you later find out. You say you found out. But of this affidavit, it's difficult to see how you as an investigator would have said, yes, this information speaks to a potential crime being committed that warrants me to investigate further. That's a difficulty I have.
Thank you, Chair, Commissioner. This is just one allegation, an appointment that came through amongst others. So it's just not just one thing. It was a whole lot of allegations on different vetting issues, no security clearance, vetting manipulated. So it's a whole lot of different allegations that's there. So I'm not looking at the one and singling it out as an appointment. I'm looking at it holistically. There are allegations, there's serious allegations here with regards to other matters. That's where I'm taking it from. Not just one single allegation has come to me about, in just that one, an appointment of a person on bordering on an HR thing with all the work that we have. This comes in a package of alleged corruption and crime intelligence.
Here's my challenge, and I think you will have to make a decision. Either you read this A1, which is the first statement in your docket. Either you read it in the context of another document, which could, the only one I can think of is the Section 27 affidavit. But as you correctly point out, you testified that you said you've never had sight of it. You only had sight of it recently. I have got no basis to gainsay that, so I accept what you say. You didn't see the Section 27. But I want to know the document that precedes this one, this statement, that you took into consideration to understand that the issues are bigger than just employing that civilian. Which document is that? Sorry, if I may finish, I do apologize. I know I'm aware of the various other statements in the docket, but they all succeed this document. They come after this document, so they are not relevant for purposes of my question. The only other document you'd have taken into consideration is one that either came into existence at the same time as that one or preceded this one that we have. What document is that?
Thank you, Chair, Commissioners. Here's my response, and which I've said before, that there's no other document, and I said the Section 27, I had no insight into it. The briefing from Chief Perumal on the investigations and what has been done there and what we need to do moving forward. These are the allegations. There are dockets that were opened in Cape Town. There were dockets opened here. These dockets are with the inspectorate. Okay. So the first was to retrieve the dockets. And on the basis of what is being said, the investigation starts where we request documents and subpoena documents, and where we identify witnesses, we start from there.
What I personally am desperate for is to understand how employing a civilian, that act ends up with including concepts such as gratification as defined.
And who to charge and what charges there are. So I'm going to move from there. When we look at the charges that are there, the gratification in terms of Section 1 of gratification, the definitions of gratifications in Section 1. And it describes what a gratification is. That is an offer of employment, agreement to an employment. So this deals with the employment of a person which falls under the definition of a gratification in terms of PRECA. So when we... I apologize, but don't rush through it because I'm very concerned by what you have just said. Gratification can be an offer of employment. Let's go to the definition and perhaps read it correctly, right? No. Because what you just said I don't think is legally correct. Gratification in the definition of gratification under PRECA, employment, contract of employment falls within the definition of gratification in the Prevention of Corrupt Activities Act.
Refer to your page 2427 and let's read it correctly, because you don't want to create the impression that offering somebody, giving somebody an offer of employment constitutes gratification. No, that's not what you intend to say. So, and I know that you want to use that definition for us to understand what gratification includes. And that's why I said this was what, June 2024, 25. So read and acquaint you and reacquaint yourself. And then let's try again.
It was not given immediately. It is said at any given time. So he held a position of power over her.
Colonel, I think you're missing the point. And sorry to interrupt.
No, by all means, Commissioner.
The point here is that accepting for a moment that employment is gratification, you must be giving that in order to influence the other person to do something illegal.
Yes, sir.
Because reading that section, it says, in order to act personally or by influencing any other person so as to act in a manner that amounts to illegal, dishonest, unauthorized, and all of those things. Now, in this case where your offer of employment and contract of employment says your job is to provide services to the South African government, because we have the contract of employment here commencing 1 November 2024. Yes, and it says, when you get into this role, you must provide these services to the government. So it's in that context that the question is asked. So it can be that she's going to give something in the future, because her providing a service or a labor to her employer, that's not what the section contemplates and what the definition contemplates. It contemplates that in return she must do something illegal, something improper, something unlawful.
Yes, sir. That's what I'm saying, is that what she was going to do is not going to be done immediately, but what she's supposed to give back was not going to be immediately, but can be given at a later stage because of the position that she was appointed in.
She was going to do something illegal.
Correct.
Some years later.
No, we do not know when that would be. But
Precisely the problem.
Because you don't know, that's precisely the problem.
That's precisely the problem
Yes.
with this. That you have you formulated a charge, you got a warrant of arrest, you got people arrested, you have people appearing in court, and continue to do so on the basis of something that you say, and rightly so, fairly so. You say, well, we don't know, maybe in future she was going to do that. How does that, for a seasoned investigator, how does that sound right? As you say it, we don't know, maybe in future she was going to do that, and you've taken all these drastic steps that have a consequence on people's lives and have had a consequence. And you sit there now, many months later, you say, well, we don't know. Maybe she was going to do it in future. It cannot be right. That's a basis on which you went and instituted this prosecution and got a warrant of arrest. That's precisely the problem with this.
And my concern, Colonel, is that the date of the offense is listed in A1 and the supporting annexure as October 2024. But she signs the contract of employment in December 2024. So 2 months after the date of the offense. And the effective date is 1 November 2024. And if you are saying this offense, which amounts to acceptance of gratification, the material facts relevant to it, happened in October. But some years from now, we don't know when. We think it's in exchange of her doing something illegal. I mean, that's circuitous reasoning with the lead up. How did you deal with documents? For example, I asked you a question. Let me give you an example. I asked you a question earlier about whether the advert was, inviting people from outside to apply. And your answer to me was, you were not aware at the time, you became aware now. Now, I've read your affidavit, the same affidavit we're looking at, from June 2025. And in that affidavit, you say so, in so many words, that this position was advertised externally. So it means in June last year already you knew that to be the position because you put that in your affidavit. Again, that's the lead up. That's not what happens in the criminal code.
Commissioner, if I could just stress the affidavit, part of it, and the advert. I did not say that it is now. Only get to know now. When the documents were subpoenaed and we got the documents, the whole appointment documents, the advert was there. So it was clear when we received those documents in February, March 2024. No, 2025. I just got to get the date right. When we received those documents, then the advert was there. All the applicants' documents were in the bundle. So there we saw it externally. And we also noticed that it was advertised previously too as well. Thank you, Commissioner. Investigations against them. So to give you an example, when you look at one panel member, and I'm actually branching out into something that I didn't want to, but when you look at the first docket that we were investigating, that is the matter of General Ushaba and the alleged housebreaking. and where a classified laptop together with an iPhone cell phone that was stolen, there was no real investigation done there. However, General Lushaba was supposed to be charged, but he was not. When General Khumalo took over as the acting divisional commissioner a couple months after this incident took place, Khumalo put in documents for the loss of the state property. In the lost property, in those statements, it was said that he was drugged. A board of inquiry should have been instituted and disciplinary steps should have been taken against Lushaba. General Khumalo did not do that. General Lushaba was not charged. Fast forward, investigation takes place. General Lushaba is charged for defeating the ends of justice. A disciplinary takes place and he's found guilty for the negligent loss of property, which is also that loss of property and the disciplinary is also that we are also still looking at, because a formal investigation was taken place directly after he reported that incident. And the general that investigated, who was tasked to investigate it, said he was a victim of being drugged by these ladies of the night. When we looked further into the investigation, which they didn't even look and probe at, we found that he was not drugged. Commissioner?
You want me to repeat my question?
Yes, Commissioner.
The panel that interviews, and in this case, let's be specific to this case, the panel is constituted, you say it was constituted by General Khumalo, you say that, and you say he holds this very powerful position, and having appointed Ms. Mukwele, the General Khumalo would have been able to control her or to influence her.
Yes.
My question is, does the interviewing panel make the appointment of the employee in the SAPS?
Thank you, Chair. Thank you, Commissioner. I think this part of it comes up, well, I recommended, I didn't appoint. When we look...
What is your answer to my question? Let's not do a long explanation. Does the interviewing panel does an interviewing panel in the SAPS, and in particular the interviewing panel that interviewed Ms. Mukwele, did it appoint her? Is it this panel that appointed her?
That's the panel that appointed her.
The panel appointed her?
Yes.
Thank you.
Sorry, Commissioner, I didn't understand the first time.
Okay, thank you.
It's that particular panel, chaired by General Khumalo, appointed by General Khumalo, chaired by General Khumalo, that appointed Ms. Mukwele.
Okay, so they didn't make a recommendation to somebody else. And I started off by saying I'm ignorant about the SAPS processes, recruitment processes. So I come from a different field, which is you interview, you recommend, somebody appoints. You are saying in this case, the very panel that interviewed her made the appointment.
Chair, Commissioner, let me disqualify what I said. It's recommend, but that recommend for me, although it's recommend, it's a given that she's going to be appointed.
Well, my question, let's go back to my question then. Don't tell me it's a given, because that's an opinion. You're expressing an opinion. I'm not interested in your opinion. I'm interested in facts. This panel that interviewed Ms. Mukwele, is your evidence or testimony that that panel appointed her? Because it's a simple matter. There is a letter of appointment somewhere, right? Or there's a minute somewhere. So we can verify that if we need to. But right now, I'm speaking from your knowledge because you're testifying and you took certain steps. So my question is simply this. Are you saying this panel appointed as a matter of fact and as a matter of law, because it has consequences, that she was appointed by the panel?
Can I respond, Commissioner?
That's what you say. Thank you.
Thank you, Chair. Thank you, Commissioner. Let me be clear on it, Chair. This panel recommended Mokwele to the National Commissioner to be appointed, which eventually led to her appointment indeed. That's my answer.
So, okay, let's reprise your answer. So you say now, she was appointed by the National Commissioner.
Correct.
That's all. See, it was easy. That's all I wanted from you.
Yes.
Thank you.
He's the one that eventually signs off.
He's the one that appoints.
Sorry.
He's the one that appointed her.
Finally, yes, he signs off on the appointment.
Thank you.
Chair.